Good afternoon. Welcome to this discussion of the healthcare law in the Supreme Court. My name is Stuart Taylor. I'll be an unobtrusive moderator, and my main job is to introduce our four highly distinguished panelists. Briefly, their bios are available if you want to know the fuller reason. In the order in which they will speak, first will go Professor Randy Barnett of Georgetown University Law Center. He teaches constitutional law and contracts. He's written more than 100 scholarly articles and reviews, as well as 9 books, a gazillion op-eds. The last big federalism case in the Supreme Court, Commerce Clause case, I should say, he argued in 2004, Gonzalez versus Raich, the California medical marijuana case. And he's been all over TV, and he's done an infinite number of these programs already, so I think he's prepared. Second will go Neal Katyal, professor at Georgetown University Law Center and senior partner at Hogan Lovells. Of course, he was acting Solicitor General and previously Deputy Solicitor General under the Obama administration, where he argued major Supreme Court cases, Court of Appeals cases throughout the nation. He's argued 15 Supreme Court cases, I think, one of which he won was Hamdan versus Rumsfeld, a big Guantanamo presidential powers case, which was described by Walter Dellinger, who comes later, as simply the most important decision on presidential power and the rule of law ever. And that Neal won that case. Third will go Kevin Marshall of Jones Day. Kevin assists clients with analysis, strategy, and advocacy involving novel or complex legal issues at all levels of the federal and state courts, pre-litigation, including internal investigations, and before regulatory agencies. He's part of the Jones Day appellate team and represents the National Federation of Independent Business in its challenge to the constitutionality of the healthcare law. Before joining Jones Day in 2007, Kevin was a Deputy Assistant Attorney General in the U.S. Department of Justice's Office of Legal Counsel. And last but not least, will speak Walter Dellinger, a member of the appellate practice, senior partner at O'Melveny and Myers, or is it just O'Melveny now? And visiting professor of law at Harvard University.
O'Melveny and Dellinger.
O'Melveny and Dellinger. And he's been at Duke Law School since shortly after the Civil War. Walter's cases include Heller versus District of Columbia, the big gun case, and some others which he actually won. He was Assistant Attorney General and head of the Office of Legal Counsel after having served in the White House from 1993 to 1996, acting Solicitor General 96 to 97, prevented from being Solicitor General only by a nasty grudge that some member of the Senate held against him based on matters unrelated to his skills. And his recent successful arguments before the Supreme Court include a long list: Jackson versus Birmingham School District, Brown versus Legal Foundation of Washington, and others. With that, two side points. Each speaker will go for 10 minutes, and then I'll bring to his attention that the 10 minutes are running out in the order in which he spoke. And Neal Katyal has to leave at 1:30 to catch a train to debate some other law in some other place, and so he will be the first person I ask the questions of. Thanks. Randy?
Well, thank you, Stuart, and thanks to the Federalist Society for having me here. I have debated or been on panels with or testified against Walter Dellinger so many times that I've lost count. We certainly know each other's positions quite well by now, and so we just use numbers. Number one, number two. My colleague, Neal Katyal from Georgetown, I don't think we've been on a program on this subject yet, although I attended all his oral arguments, ably representing the government's untenable position on the affordability, on the constitutionality of the Affordable Care Act. And when he got up there and he was being grilled by the judges, my overriding reaction during watching him was, Boy, I'm glad I'm not doing that, and I'm glad he's doing that. So, and that wasn't even about the side. It's just the preparation it takes to go into doing this sort of thing for real, as opposed to off the top of your head, which is what I'm going to do right now. So I'm going to, instead of getting into the weeds of various of issues, I'm going to try to keep things simple. I'm not going to talk about the Anti-Injunction Act. You'll be, I think, happy to know, unless it comes up in questions. I'm not going to talk about even the tax theory right off the bat, although it may be brought up by other speakers. I'm not going to talk about severability, and I'm not going to talk about the Medicaid challenge. I'm going to limit myself, since I now probably only have 9 minutes left, to talk about the constitutionality of the individual insurance mandate, which requires that every person in the country obtain insurance from a private party or from the government. And so that's what I'm going to talk about. And I'm basically going to make 4 points about the constitutionality of this measure. And I can give you 4 words to describe, one word to describe each of these 4 points. That the insurance mandate is unprecedented, it's uncabined, it's unnecessary, and it's dangerous. So let's just start with unprecedented. It was really the first argument that was most prominently made against the individual mandate. And what do I mean by unprecedented? I mean literally, this has never happened before. Never in the history of this country have the American people as a whole been required to do business with a private company upon pain of a penalty. Had this ever been, I can prove that this has never been done before, because had it ever been done before, you'd all be aware of all the contracts that you have to enter into or pay a penalty or a fine if you don't. None of you are aware of any such contracts. Neither are your parents or your grandparents aware of any such contracts. Why? Because this has never been done before. And that is why it's unprecedented. Not only that, you don't have to take my word for that. Every court that has considered this question, including the courts that have held the mandate, have agreed that this is an unprecedented claim of governmental power. Now, as you know, some courts have upheld the mandate, not just struck it down, and so it does not follow from the fact that something is unprecedented that it is necessarily unconstitutional. There's a first time for anything or for everything, and sometimes Congress does something new, and what they do that's new is constitutional. So the fact that it's unprecedented is not necessarily a deal breaker, but there is in fact a precedent for the idea that the unprecedented nature of a claim of power is constitutionally relevant, and that's Justice Scalia's opinion in the Prince case, where he said that the fact that a particular power is this attractive, and in that case it involved a mandate also, and only it was a mandate being imposed on state governments, on the legislatures of state governments. Any power that's this attractive but has gone for 220 years without being discovered and exercised by Congress, that there is reason to believe that power does not exist. So this is a very attractive power, one that Congress would like to have used in the past, had it at their disposal. And yet for 220 years we've managed to solve all kinds of problems in this country, including free rider problems and cost-shifting problems and all kinds of other problems in this country without giving Congress this power to impose economic mandates on the people. All right, so that's point number 1, unprecedented. Point number 2, uncabined. This claim of power to impose economic mandates of the people has no identifiable and no judicially administrable limit. In fact, to date, the supporters of this bill have been unable to identify a judicially administrable limit. During oral argument in the Sky 7 case, or 7 Skies case? Seven Sky, thank you. In the Seven Sky case, Neal's successor, who was arguing this case, was asked by the court for about 10 minutes to state any economic mandate, to identify any economic mandate that the Congress would be unable to impose under the government's theory justifying this economic mandate, and she was unable to identify any single example of a mandate that the Congress could not impose on the people. And I understand that during that when the Justice Department filed their briefs in this case, they had a press conference in which the reporters asked them to state a mandate, any example of a mandate or a limiting principle, and they were similarly unable to identify one. The only thing that the government, let me just say that right off the top, that's a bad position for the government to take, I think. That's a position that is not likely to be successful. To say that there's this unlimited power in a regime of limited and enumerated powers is a difficult position. The only argument that the government has stressed from day one and continues to stress is that as a factual matter, health care is somehow different than other economic issues, other economic matters. And there's an argument to be made for why health care is different. It involves unanticipated expenses, and these expenses can be very great, and it's not clear that everybody knows how to pay for them, and then there's a government mandate that insurances provide emergency care. So there's a factual story to be told why health care is different. But the problem with this is that no matter how you tell this story, it still does not amount to a judicially administrable limiting principle. Why? Because were it to be accepted as a judicially administrable limiting principle, it would mean that the courts would then have to get into the business of distinguishing this factual circumstance from the next mandate, the factual circumstance supporting the next mandate that the Congress might choose to enact. And that is a kind of factual inquiry, a fact-based inquiry that the courts have for a very long time refused to get into. Instead, using rational basis scrutiny, deferred to Congress's assessment of the facts. So the truth of the matter is, and everybody in the courtroom next week is going to know, that unless there's a judicially administrable mandate, limiting principle that is identified by the Solicitor General next week, it means that upholding this mandate for the reasons being offered on its behalf will mean that the court will not examine the next mandate to see if it's more or less justified than this one. It will mean from now on, Congress, in its own discretion, will be able to impose economic mandates without limit. And so in that sense, the court's going to have to bite the bullet and say something it's never been willing to say before about the unlimited nature of Congress's power under the supposed Commerce Clause. Now the third point is that it was really unnecessary. This law was really unnecessary. And why? Because Congress has ample powers to address free rider problems, cost-shifting problems, all the problems that this mandate is said to address. And the powers that it normally uses to address these problems is its taxing and spending power. Its taxing power means that it can coerce people to pay for things, to pay money for the government, and then the government can disperse that money to people that require subsidies. Like in this case, it might be the insurance companies. So you coerce the general public to make a payment to the government, and then, as typically the case, the government who is forcing hospital providers or the insurance companies to do something provides a subsidy to those providers in order to do that. And so that's how we normally decide these kinds of questions. That's the sort of normal way in which Congress for 220 years has addressed this sort of problem. Well, why didn't they do that here? We know the answer to that. The reason they didn't do that here is because of politics. It's because the president made a pledge in the last presidential election that he would not raise taxes on people making $200,000 or less. This would have violated that pledge. It's the reason why he denied that the penalty in the mandate was in fact a tax when he was asked by George Stephanopoulos. There were not 60 votes, there were not 60 Democratic votes in the Senate for any kind of new tax to be imposed on the American people, and that's why they didn't do it. That's why, in the Senate at least, they decided on this mandate of dubious constitutionality, which they were warned about by the Congressional Research Service before they voted on it, before they approved it out of their committee, but they decided on that just to avoid the political accountability that comes with exercising your tax power, so they didn't do it. However, if this mandate were to be struck down, Congress retains the powers to handle these questions if they have the political will to exercise those powers, and then we'd have to see how they would address the health care problems that we have using constitutional means. Now, my last point is that upholding a mandate like this is not only unnecessary, it's actually positively dangerous. And why is that? Because when Congress normally exercises its powers of taxing and spending, the consequences of not doing what Congress wants you to do is essentially monetary. So in the Cash for Clunkers program, for example, if you don't want to buy a new car, you don't want to trade in your old car, basically you're giving up a major subsidy for that activity. And so the consequences to you are pocketbook consequences. And that's true of most all of the taxing and spending authority when it's used to induce Americans to do things that Congress does not have the power to directly order or command them to do. However, if this individual economic mandate is recognized as constitutional, from now on, even though in this case the penalty was limited to a monetary sanction, from now on the full panoply of sanctions that are normally available to enforce Commerce Clause regulations will be available in the future. And those include up to and including imprisonment for the failure to obey a future mandate. And that's a very dangerous power to entrust Congress to do. All right, so I have 1 minute left, and let me just address the issue of how we're going to do in this case. Everybody wants to know how we're going to do in this case. I will not make a prediction on the outcome of this case, and don't know if, Stuart, you mentioned that I was one of the lawyers for the National Federation of Independent Business in your introduction.
Sorry, I didn't.
So you should all be aware of the fact that I am one of the lawyers involved in the case, and so I'm not going to say anything about what I think the outcome is. But I do think, however, our chances are greatly improved by the fact that this particular mandate is highly unpopular. I don't have time to go through the polling data that has come out, but last fall, for the second year running, the Associated Press and the National Constitution Center did a poll on whether the American people think that Congress ought to have the power to make you have insurance with private companies, and 82% of the American people thought that they should not. 16% of the American people thought that power should exist. And just 2 weeks ago, the Associated Press and USA Today, that was the Associated Press and the National Constitution Center, but 2 weeks ago, the Gallup organization, together with USA Today, did a poll asking Americans, do you think the mandate is unconstitutional? And the answer was 72% of the Americans thought it was unconstitutional, including 56% of Democrats polled who thought it was unconstitutional. 54% of people who thought the Health Care Act was a good idea thought it was unconstitutional. Only 20% of the American people thought this mandate was constitutional. Now, I'm not suggesting that the Supreme Court will strike this mandate down because it's unpopular. But I do believe that the unpopularity of this law gives the Supreme Court the opportunity to evaluate fairly a valid constitutional objections being made against it without fear of a popular backlash, without fear of its legitimacy being undermined. And that, I think, levels the playing field so that the Supreme Court are going to decide the case on the merits, and I believe the merits favor the challenge. Thank you.
Thanks very much, Randy. Next comes Neal Katyal.
Thank you. It's a real pleasure to be here. I love Federalist Society events and the commitment to public debate that the organization represents. And so I always try and come to any invitation that Dean gives to me. And it's also a real pleasure to be here with my colleague Randy at Georgetown. So let me first start with what Congress was doing, because I have to say that before I got involved in the issue, I didn't really understand it during the passage of the debate in Congress and so on. So here's basically what Congress saw. They saw an insurance market where 50 million people, roughly 50 million Americans, lacked health insurance. Many of them lacked it because they had pre-existing conditions or insurance companies feared they had pre-existing conditions. And so it was freezing them into their current jobs and also making everyone else, you and me, essentially pay for their health care, because they would then show up at the emergency room after suffering from whatever ailment, and they wouldn't have the means to pay for it. And so that bill would get stuck and tacked onto all of our insurance bills. Congress found to the tune of $1,000 a year. The average American family was essentially paying a hidden tax of $1,000 a year because all of this 50 million uninsured. And so what they said is, what Congress said, and by the way, it is an act of Congress. It's the Affordable Care Act. I know the panel title is Obamacare, but I do think it's important that we recognize that this is an act of Congress entitled to all the solemnity that acts of Congress are entitled to. So what Congress said in the act was that we're going to ban discrimination against pre-existing conditions, so that if you want insurance, you're going to get it at the prevailing rate for people in the community. Now, there was a problem with that, and they knew this because 7 states had tried to do that. When they did that, what happened was that people would wait until they got sick. They literally wait until they were in the ambulance en route to the hospital before signing up for insurance, because it makes sense. If you know your guaranteed issue, that you're going to get insurance whenever you want it, you'll wait until you actually need it and then stick everyone with the bill. So the 7 states that had done that had led to any number of insurance market problems. Now, there was one state that I know some of you in this room are familiar with that did something different, and that was Massachusetts. And what Massachusetts did was it said, okay, we're going to get rid of discrimination and the pre-existing condition discrimination, but at the same time, we're going to take this idea from the Heritage Foundation that everyone carry a certain minimum amount of insurance. And by doing so, you avoid the adverse selection problem. And that actually didn't work perfectly, but it worked pretty well. And that's the model Congress used. And that's why when we talk about this individual mandate. That's why it exists, is to avoid, to avoid the imbalance that would have been created by the intervention into the healthcare market to address this problem. Now, I do think that the challengers have an extremely difficult argument. They have the greatest advocate in the world, Paul Clement, but I think it's a very hard argument to make, and that is, both on commerce grounds and then on tax grounds. On commerce grounds, the government is saying insurance is the way in which people finance their health care decisions. That is undoubtedly economic. That is, health care is 17.6% of our gross domestic product. Insurance is the way people predominantly pay for their health care. And insurance is itself, of course, quintessentially economic. So this isn't like the cases in which the government has lost in the Commerce Clause area, things like violence against women or guns near schools, which have a tenuous connection to commerce. This is something that really is the heartland of what commerce is all about. It's about financing. Now, the government's argument is not that the failure to buy something is economic. The government's argument in this case is that everyone is going to consume health care, and it's the failure to secure financing for that health care that everyone consumes that is the economic effect, that is leading to the $1,000 in cost for the average American family that often crosses state lines. Now, the government also has a second Commerce Clause argument, and that's based on Justice Scalia's concurrence in the Raich case, the medical marijuana case that Randy had argued. And in that case, Justice Scalia said, look, not every jot and tittle of legislation has to affect interstate commerce. As long as it's part of a comprehensive scheme that affects interstate commerce, any individual provision within it could be constitutional. And so I do think that there's a second argument on necessary and proper that I think provides the government a fair amount of latitude. Now, Randy says that the government hasn't offered a limiting position. And I think we should distinguish between principles that the government has offered to limit the exercise of the Commerce Clause and answers to any individual hypothetical case that a judge might throw out at oral argument. I can just tell you, having had the privilege of representing the government in these set of cases, but also in any others, a government lawyer represents not just the president, not just this Congress, but future Congresses. And the last thing you want to do as a government lawyer is bind the hands, because you don't know what Congress is going to do in 20 years when it's controlled by, by someone else. And you don't want to have some future Solicitor General have read back to her or him the statement, oh, well, your predecessor said it was unconstitutional. So that's what accounts for it here. It accounts for it in every Commerce Clause case. It spans administrations. This is not different. Now, what the government has done is offer, I think, 4 limiting principles, which I do think block many of the hypotheticals. So, like the government can force you to eat broccoli because it's good for you hypothetical. The first one is an ironclad one. It's that the Bill of Rights cuts across Congress's Article 1, Section 8 powers, so that individual privacy, other things, will constrain the ability of the government to impose certain mandates and certain hypotheticals. The second is that this is truly economic in nature. This isn't a tenuous connection like violence against women or something like that. This is something that it really is the heartland of what commerce is all about, how goods are paid for. The third is that that the government is saying here that this is truly an interstate problem. Remember, the text of Article 1, Section 8 is that Congress can regulate commerce among the several states. And what the government is arguing here is that states individually are not competent to solve the problem. And even when Massachusetts did the one good reform it did, it led to a magnet for uninsured folks to come into the state. And so no one state alone can do this. It requires a national solution. And that's really different than violence against women or guns in schools, in which states have incentives on their own to deal with the problem. But this is something that's truly national. It requires a federal solution. Healthcare is something that has any number of profound interstate effects. And so many of the hypotheticals that are advanced will fail that test. And then suppose, the last one is, suppose that we're wrong about this, and suppose the government can do a bit more than it has been able to do now. Well, politics, as Chief Justice Marshall said in McCulloch, is ultimately the test. and will constrain a bunch of the kind of hypotheticals that you'll get. Now, I understand that that's not a perfect solution. I don't think Chief Justice Marshall thought it was a perfect solution, but I do think it's important when approaching constitutional cases to not decide them on the crazy hypothetical, because the crazy hypothetical is something that we will never see the light of day. I think I probably only have a couple of minutes left, so let me just end it by saying this. Suppose that it's close. Suppose I don't persuade you. I don't think, I don't come here with any illusions. The thing that I want to leave you with is, this isn't just about this case. This is about how you think about the Constitution and judicial restraint. And to me, I went to law school in 1992 to 1995, and the most profound idea I got from my conservative friends, and it's an idea that I've taken incredibly seriously in everything I've done, is this idea of judicial restraint. You had this idea, and it was so powerful, the idea that the unelected Supreme Court shouldn't be taking democratic decisions away from the people. And when I hear Randy's arguments, on particularly his third argument, that the health care mandate's unnecessary, the fourth argument, that it's dangerous, the kind of fifth argument, that it's unpopular, I do start to worry that, that these are incursions into the democratic process. I am guided by what James Bradley Thayer said over 100 years ago, when he said, if constitutional questions are close, if they're close, then you defer to the legislative process. I think that's what Judge Sutton did. I think that's what Judge Silberman did. I think that's what Judge Wilkinson said last week. Those are, to me, some of the leading lights of what this great society has been all about. And I do make this challenge on the left, too. I think, you can't be for activism, in certain cases, but not when it comes to this case. I mean, I think both sides have to really think about this in a principled way. But I am deeply concerned that, that the great intellectual energy, behind this case is taking away from something that all of you have stood for proudly for a long time. Thanks.
Thanks very much, Neal. Kevin, you're next.
After Randy has given his well-honed stump speech of the last 3 years, it's a serious question what more there is to say in defense of the suit. I'm going to take it from the perspective of considering the implications of the suit and how it comes out. So set aside the question of the thrill of victory and agony of defeat. What difference will the suit make? Randy, in his 4 points, emphasized what happens if we lose. I want to start by thinking about what happens if we win. And my message to Professor Katyal is he has very little to worry about. In fact, our suit is a quite humble one, an effort at defense. And I think it gives the court an opportunity to reinforce the structural limits of the Constitution that protect our freedom, but do so in a way that is not going to disrupt anything else. And in that, it's actually much like Lopez and Morrison. So what would it look like if we were to win? I should say there is probably an infinite number of permutations of how this case could come out. I'll just consider, what if we win everything, and what if the government wins everything? So if we win, it means the court hears the case on the merits. The Anti-Injunction Act doesn't apply, and I also will not talk about that unless there are questions. The court strikes down the individual mandate. It would have to find both that it's not a regulation of commerce or necessary and proper to a regulation of commerce, and that it's not a tax. And the court would then hold the rest of the law not severable from the individual mandate, which would actually be a way for it to avoid the Medicaid question and the coercion doctrine, which I also will not talk about. So let's start with just the real-world policy question. If the whole act falls, well, there's not much reliance. The law is only 2 years old. Much of it hasn't even taken effect yet because of the various budget gimmicks used to get it through, and some of the parts that have taken effect haven't been implemented yet. But consider it from the perspective of health care policy, and I'd submit that a ruling in our favor would actually impose very little constraint on Congress and the President in starting over, even if you generally agree with the policy approach of Obamacare. And I know there are some such people out there. And let's consider it from the perspective of the three rationales for the individual mandate. You might wonder why, if the individual mandate increases demand for insurance, Congress thought it would actually reduce premiums. The reason is because of the provision in the law called community rating, which means that it prohibits insurance companies from pricing the insurance policy according to the customer's risk. So what that means is that the individual mandate is actually a cloaked subsidy. Relatively healthy people overpay for insurance that they don't want and probably won't need. That extra premium then subsidizes the insurance companies who can keep premiums down for others. Well, Congress could replace its cloaked subsidy with the transparent one, using the tax and spend power, as Randy mentioned. Another argument that we heard, including from Professor Katyal, was about adverse selection or strategic timing. Wait until you're sick, then buy your health care insurance, and you've saved yourself a lot of money. Well, one way you could accomplish the same goal of preventing that is by having open enrollment periods and providing that once people do enroll, their insurance doesn't take effect for a while, a waiting period. And it turns out Obamacare already provides for that. So there's nothing more to do. You could expand those approaches if you really wanted to. And third, the individual mandate is supposed to address uncompensated care. Given the government's argument and what Professor Katyal said, one could be forgiven for thinking that the individual mandate actually regulates one's obtaining of health insurance, or even whether one pays or not, that it actually regulates how one obtains health care or pays for it. It doesn't. You have to buy health insurance, but you can use it or not. Whether you get health care at all doesn't matter. Well, Congress could actually regulate the thing that it says it's caring about. It could impose a penalty when you get health care if you don't have insurance. And from the perspective of the patient and the health care provider, this would be just the same, except it would be cheaper for the patient. It would only cost more to the insurance company. And again, Congress could use its taxing and spending power to overcome that. Let's consider from the perspective of law, now that we've covered policy. As Randy pointed out, and many others have, the individual mandate is unprecedented. That's been said ad nauseum, and it's been said ad nauseum because it's true. That means that if the individual mandate falls, nothing else will fall. No other law will be imperiled. One way to illustrate this is to look at the two precedents that set the outer limits of the commerce power and on which the government relies, Wickard and Raich. Regardless of whether you think those laws support the government, there's no serious argument that a ruling that the individual mandate is unconstitutional would require overturning or even imperiling either of those precedents. So, to use Raich, the government could still prohibit the intrastate production and possession of drugs in the name of prohibiting interstate commerce in those commodities. Or to use Wickard, the federal government still would have the option of limiting intrastate production of particular agricultural commodities in the name of raising prices of those commodities in interstate commerce. And when one understands this, the arguments that the plaintiffs are trying to carve out some special exception from Congress's power ring quite hollow. I would add the same is true of the tax power. A ruling that the individual mandate is not a tax would do nothing to imperil any of the tax cases since the New Deal, uniformly upholding Congress's actual exercise of its tax power. Then what if we turn it around? What if the government wins everything? Again, this would mean the court would hear the case on the merits. The Anti-Injunction Act wouldn't apply. The court would uphold the individual mandate under the commerce power. It wouldn't get to severability, and it would uphold the Medicaid expansion. Now, from the policy perspective, of course, this would do very little. The government would be told to carry on. But from the perspective of the powers of government, the relation of citizens to the government, and government's relationship to business, the implications would be immeasurable. Again, because the individual mandate is unprecedented, Congress would be getting a new power. And it's new as a practical matter, regardless of what you think of the legal question. It's also a highly attractive power, to quote Justice Scalia and Prince. The CBO has actually helped to highlight the beauty of what the individual mandate does. It allows Congress to provide a subsidy without any change in total federal receipts or outlays. They don't need to impose a tax. They don't need to spend money and threaten the deficit. It's actually extremely convenient. It's a fraught power, as Randy pointed out. There's no particular reason the sanction needs to be as modest as the sanction under the individual mandate is. So the effect would again be there's no limit to the federal government's ability to meddle in the lives of its citizens and play favorites in the economy. And again, you don't have to take my word for it or Randy's word for it. The D.C. Circuit pointed that out in upholding the mandate. The CBO pointed it out in assessing the implications of the mandate. Professor Katyal has largely admitted it by identifying a series of alleged limits that actually aren't. So, for example, the Bill of Rights. That argument fails high school civics because we all learned that the reasons that the Bill of Rights was passed and, frankly, opposed, the reason it was opposed was because it would lead to precisely the argument that Professor Katyal has identified. And the argument made against it was the enumeration of power is the primary safeguard of freedom. If we add a Bill of Rights, people might forget that, and apparently there was some weight to that argument. So let me take some of the hypotheticals rather than speaking in generalities. I'm not going to talk about broccoli, but I'm going to just walk through some of the arguments for the mandate and use some of the hypotheticals that are actually in our brief until I'm told to stop. And a lot of these are variations on two things, Wickard versus Filburn, the Wheat case, and the General Motors bailout. So do you think that regulating commerce includes the power to order commerce into being? Well, then, because the government could regulate the terms of contracts between General Motors and its customers, it could also compel people to enter into contracts with General Motors. You think that the power to regulate commerce means the power to direct commerce, which means the power to command commerce? Then by the same logic, the power to direct traffic means the power to go out onto the street, go into the garages, and pull people in their cars out into the street. It means the power to tell pedestrians that they have to buy cars. You think that the non-purchase of insurance is an economic decision, which is essentially an economic activity with a substantial effect on commerce. Then any non-purchase of a product is an economic activity that imposes a substantial effect on commerce. We could use the Wickard analogy. Mr. Wickard isn't buying wheat. Well, we can order him to buy wheat, and when he buys wheat, that will in a small way affect the market for wheat. If we multiply that across the whole country, we have a substantial effect. Similarly, the decision not to purchase a car substantially affects commerce. By that logic, Congress could order people to buy cars because that will help General Motors. And perhaps what you want to do is compensate for the effects of government regulations like community rating and guaranteed issue. Well, is that really all that different from ordering people to buy a car because environmental or safety regulations have raised the price so much no one wants to buy it? You call it the Chevy Volt rule, perhaps. And then I'll conclude with an example about cost shifting. And again, remember, what the individual mandate does not do is regulate one's obtaining of health care or one's paying for the health care. Rather, it regulates everyone now because of a prediction about what some subset of those people will do in the future. Well, most people will eventually buy a house. Why wait until they buy the house to require them to get mortgage insurance? Make them do it now, because it's very likely that they will buy a house, and some subset of those people will default on their mortgage. Finally, the main response to all these things is the argument that healthcare is somewhat unique. Randy's already explained why that doesn't work. If that's your defense, what you're doing is you're admitting that the individual mandate is a means for carrying into execution the interstate commerce power, which we deny. And all you're reduced to is arguing over whether the government's choice of means is or is not necessary, convenient, or useful, which is an argument you will always lose, and Professor Katyal has pointed that out when he's emphasized the solemnity of congressional choices and the need to defer to the legislative process. Professor Dellinger did the same thing in his brief. So we're left with no limits at all.
Thank you, Kevin. Thank you, Kevin. Walter Dellinger will talk now.
I want to make the conservative case for the Affordable Care Act and the conservative case for upholding the Affordable Care Act. Let me begin by saying that I think the answer to the hypotheticals is really quite easy. If the question is, does the government's theory, under the government's theory, could Congress require people to buy a General Motors car? No. I'll go back to that at the end of my remarks. Let me begin by saying why there's a conservative case for the Affordable Care Act and how that plays into the case for its constitutionality. First of all, the effort to insure 30 million uninsured Americans is not simply a matter of social justice. Uninsured Americans and the dysfunction that is causing in our healthcare system is having very adverse effects on the national economy. What happens to that enormous number of uninsured persons, far greater than any developed country in the world, is two things. One, or three things actually. One, they don't get health care to a large extent. Two, they get health care at the wrong time, that is when an illness becomes acute instead of having an earlier preventive intervention. And three, they get health care in the most expensive way, that is using emergency rooms as the provider of first resort, all of which imposes enormous costs that are passed on to you, to everybody in this room. It's passed on to every person who is employed through their company insurance policies, because hospitals have to even out at the end of the year. The present method of financing it is on higher charges on other people who are sick. And that goes into the price of every American car and every American product. And the idea of bringing those people into the insured system, making sure that preventive care is part of that system, making sure that it can be done more rationally than through the mechanism of emergency rooms, are all matters that have serious national economic consequences to protect the American markets. How is it to be done? Obviously, the New Deal approach would be to have a federal agency be the provider of national health insurance for everyone in the way that it is for those 65 and older. And that has traditionally been the liberal single-payer approach. You eliminate the transaction costs of the intermediary private insurance companies. That has never been the conservative approach. Once you accept the idea of expanding coverage, there's a reason why it has always been the conservative approach to use the existing private market to provide that insurance. You can look at one of the amicus briefs. It's by a group I didn't know existed, Historians of Healthcare Policy, that sets out, beginning at about, I think, page 11, goes through chapter and verse the conservative origins of the mandate. It's not simply Governor Romney or one report from the Heritage Foundation. It was the alternative. Instead of having a national system of doing it, we ought to use the existing private market, give people the choice among existing private insurers. We need to deal with the problem that private insurers are turning down people who have pre-existing conditions, charging people rates they can't afford if they have a child born with a birth defect. Those problems are handled for everybody in this room. If you have insurance through your employer, ERISA already controls and basically provides for community rating and guaranteed coverage once you go to work in your employment circumstances. That 15% that's outside of Medicare, Medicaid, and the government insurance market that we're talking about. And of course, that is, 30, 40 million people who need the same a system of guaranteed coverage and affordable rates. Once you do that, you have the problem that General Katyal noted, that every state that tried to guarantee coverage to those who were without it, that people no longer have any reason. It's not just the existing people who are having $43 billion in uncompensated care. It's everyone who now has coverage that thinks, why should I keep having coverage? Why not wait until I get the cancer diagnosis or I'm hit by a truck? Then if I can scrawl through my Straight. I see someone in the hospital room in catastrophic care just putting their X, and they're covered from that point on. You have to have an incentive to have insurance. This is a fairly modest incentive, and I see no reason why, if a court would think there was something improper about forcing people to purchase a private product, that they could simply say that that the limited sanctions under this law are such that they give a genuine choice. They give a genuine choice. And I think that's made clear under the law by the fact that the mandate applies that everyone shall ensure that they and their dependents are covered. But those with a financial hardship and those who are members of Indian tribes who have the separate system of health care are exempt from the penalty. They're not lawbreakers. They're exempt from the penalty. Those who choose to comply with the penalty, and the government says this emphatically in its brief, are not lawbreakers. You can choose to pay, in the year 2015, with your income tax, you can choose to pay $95 if you don't have coverage. And that amount goes up, and it never exceeds 2.5% of income. And for those who are wealthy, for whom that would get to be a large amount, there's another cap that it never exceeds the amount of a relatively modest low-end health insurance policy. So in that sense, if not giving people a choice is a proprietary problem, this does, and the court can say, we wait another day when you're actually forced to do it. Now, why is it, so it's the conservative, the word unprecedented and novel is used every time, and it is unprecedented, and Judge Brett Kavanaugh identified at oral argument precisely why and how it's unprecedented. For the first time, Congress has chosen to deal with a national problem of this kind by rejecting the New Deal approach and using a conservative market approach. That's why it's novel. That's why it's unprecedented. And how would you defend? First of all, you could adopt Judge Lawrence Silberman's approach. He says the text of the Constitution says the power to regulate commerce among the states. Obviously, stimulating or requiring, he quotes Justice Jackson, that stimulating commerce and prohibiting commerce are equally means of regulating it as imposing restrictions on commerce that exists. The government, that would take care of everything, and it would mean that, of course, everything would fall with every required purchase would fall within that. That's not going to be the theory that the government is going to offer to the court. It can say, under Judge Silberman's theory, yes, you could that would be within the scope of the commerce power. But before that, Judge Silberman's approach seems shocking. Keep in mind that he's merely talking about what is within the subject matter scope of commerce among the states. When Champion against Ames was argued in 1905, and I think this is an important precedent to support Judge Silberman's approach, not the government's approach. Champion against Ames involved the prohibition of lottery tickets. You couldn't send them in interstate commerce, so no interstate commerce would exist. It went to the Supreme Court on the argument that a prohibition of commerce isn't a regulation of commerce. When you prohibit something, it won't exist. You can only regulate commerce that actually occurs. And indeed, the parade of horribles followed quickly from the lips of those challenging the first congressional prohibition of commerce, to say you could prohibit a man from moving in interstate commerce if he wasn't divorced according to the federal, divorce law. That is always true. You can always have a parade of horribles when the question is whether something fits within the jurisdictional power. But the court nonetheless said the power to prohibit it is the power to regulate commerce among the states. The Bill of Rights would impose limits on how you could regulate. But in this case, you don't need to go there. Even though, let me give an example. When the minimum wage was argued, it was said if the regulation of interstate commerce allows setting of a minimum wage of $5 an hour, it would include the power to set a minimum wage of $5,000 an hour. That was argued to the court. And of course, that's right. But I think it would clearly be a taking, it would be a due process violation. Lots of other things would kick in if you did that. Wow, 1 minute. All right. But in this case, you need not go that far because you, as Judge Sutton said, there is an existing management of the risk of health care. You can respond to the argument made by Paul Clement Paul says the Constitution grants Congress the power to regulate commerce, not the power to compel commerce. The first limiting principle is that the court need not consider that, because here you are regulating the financing of commerce in which people are already going to engage. The class of people who are uninsured are going to engage in the consumption of health care. Not every one of them, but of course that's never true of regulatory schemes. But the class as a whole will engage in substantial acquisition of health care services they haven't provided for. So that you are not calling commerce into existence, you are regulating commerce that will occur. You are regulating it in advance, but there can't be anything in the Constitution that says that you can't regulate the financing of an activity in which the class is inevitably going to engage in at one point in time rather than another. Yes, you're not required to use your insurance, but surely Congress can predict that most people who have insurance will decide to have the insurance company pay their hospital bill rather than pay it themselves out of pocket. There might be someone who wouldn't. Maybe Randy wouldn't as a libertarian. But that would be quite unusual, and Congress doesn't need to regulate that. I think we are talking about a rather extraordinary second guessing of a judgment of Congress that I think can be quite well limited to those circumstances in which you are regulating a product, the financing of a product that people are going to engage in, whereas Judge Sutton says your self-insurance is a current regulation of this extraordinary risk of uncompensated care that no one can avoid, and where it's part of a regulatory scheme of undoubted constitutionality to make the insurance reforms workable, and where the failure to have an incentive to have insurance will actually undercut a regulatory scheme. I don't think those attributes are true of any of the hypotheticals in the briefs put forward. And if someone comes up with a hypothetical that's indistinguishable, then yes, Congress could regulate that too. Thank you.
Thank you very much, Walter. I'll ask some questions and then open it to the floor in a few minutes. Since Neal has to leave for a train very soon, I'll ask him the first question. President Obama and his allies in Congress insisted during the debate that the financial penalty for failing to comply with the individual mandate is not a tax. Paul Clement argues for the 26 states in his brief that it would violate the principle of accountability in government for them to be allowed to enact legislation that would not have passed had it been labeled a tax, and then turn around and defend it as a valid exercise of the tax power. Why is he wrong?
Well, I think no one was fooled during the passage of the Affordable Care Act that this was a tax. The Senate defeated a constitutional appointive order in part on the grounds that it was a tax. The text of the Affordable Care Act itself, I'm a textualist, and I look to the text of the acts, not legislative history and the stuff around it. It uses the word tax, I think, 38 times in the individual mandate provision. If you don't have the requisite health insurance, on every April 15th on your 1040 form, you have to check a box that says you don't have enough, and then you pay a penalty, and that penalty is calculated to your adjusted gross income. So every April 15th, every American is going to be reminded that this is a tax. So I think that there are some pretty strong arguments on accountability that cut in favor of the government's position here. And before I leave, I just wanted to just make one comment about Mr. Marshall's calling this a kind of humble request. I've heard Judge Reinhart make that claim as well, that he's being humble in striking down, 50 acts of Congress. But I do think that this is pretty extraordinary. I mean, you go back and look, I think the Supreme Court in its first 150 years struck down like 2 acts of Congress. This is not the kind of legislation which, as Chief Justice Marshall said in McCulloch, passed unsuspecting into the night. This is something that a lot of Americans had their eyes on then and have now. Randy's point about it being unpopular, I don't know if that's true or not, but if it is, our founders had a very simple answer to unpopular legislation. Vote the president out of office, vote those representatives out of office, put pressure on them to change the law. Don't let the courts do your hard work for you. And, my point here is not about this case. Maybe there's some alternative way to deal with the healthcare market that Mr. Marshall has put forth. That's never been the test for constitutional principles. And I do think that the essence of judicial restraint is if the case is close, as James Bradley Thayer said, let the democratic process unfold.
Thank you very much. Randy Barnett. Next question. My question is in the spirit of what Neal was just saying. I'll phrase it differently, though. Wouldn't it be an act of judicial hubris for 5 unelected, life-tenured justices to overturn by a one-vote margin based on a debatable constitutional theory that's probably rejected by most constitutional law professors, the most important domestic legislation adopted by the elected branches in many decades? Wouldn't that be an act of judicial hubris?
Well, the fact that most constitutional law professors think that the bill is constitutional is probably an argument that cuts the other way.
You went to the weakest part of my question. Now please answer the rest of it.
I do think that it was a very important part of the president's political program, but the way it was enacted it was also unprecedented the way it was enacted. We have never in this country enacted a major piece of social legislation of this magnitude without bipartisan support. The legal historian Barry Cushman from the University of Virginia just posted an article that's coming out in the Green Bag in which he evaluates the vote count on every major piece of New Deal legislation. And there was substantial Republican support for every piece of legislation there. A lot of the New Deal passed on a voice vote. And as did all the Civil Rights Acts in the 1960s. They were all passed with a bipartisan support from both parties. Not this bill. Not this bill. We all know how this bill got passed. It was almost passed, demon pass. It was almost passed without even voting on it. That's how much the Democrats in the House didn't want to vote on this bill. They actually wanted to deem it passed. They didn't do that. Actually, they were shamed into not doing that. So they did have to have an actual vote on it. But what happened is that after Scott Brown got elected in Massachusetts and they no longer had a filibuster-proof majority in the Senate, they decided they were going to ram this vote down even the Democrats' throat, who didn't really support this approach and really wanted a different approach, their own approach. But so that it would avoid the normal Civics 101 process in which both bills go to conference, and they come out of conference, and then they have to be voted on again. But no, we couldn't have that. We had to have this vote. We couldn't go back to the Republicans and have them part of the negotiations into how this bill, how this scheme was going to be formulated. So it was passed in an extraordinary way. Yes, it was technically legal, so yeah, but whether it was democratic or not, I don't know. And whether an act that was passed in the face of public opposition at the time, polling negative even when it was passed, no, I don't think that this is something where the court is doing anything other than its responsibility to protect the Constitution. And actually, if you put it that way, it doesn't really matter whether it was popular, unpopular, passed in this underhanded way or not. What matters is that if the courts uphold this new claim of power, it will be a new, unprecedented, unnecessary, and dangerous power that Congress will have forevermore, regardless of how it's used in the future. And that's something the court has a responsibility to protect the country against and to protect the Constitution against, regardless of how important it may be to one political party or the other.
Thank you. Walter Dellinger, you didn't have time to get to the question of whether Congress could mandate that every American, or let's say every millionaire and billionaire, buy an American car. So could you address that, and then maybe also respond to what Randy just said?
Sure. The answer to that question is no. It would only be, well, for several reasons. First of all, only under Judge Silberman's opinion that requiring commerce is regulating commerce, just as prohibiting commerce is, a not frivolous opinion, but under that opinion, it would pass muster as a regulation of commerce. Anything you did to require anybody to buy any product or forbid anybody from buying a product or would be a regulation of commerce under Judge Silberman's theory, though you would have to have, in my view, the importance of the Bill of Rights is you can't put out extreme hypotheticals, and then when someone says, but the Bill of Rights would prohibit that, go back and switch the question back again. That if you required a naked wealth transfer raises questions that go back from Calder against Bull, and this is where, as Randy knows, I do have a little bit of a Cato side to me. Back to Calder against Bull, a legislative act to take from A and give to B, all the way through Eastern Enterprises. There are substantial restraints where the only thing is you're just transferring wealth from one person to another. But that's one part of the answer. The government's position is I would say, and when I testified before the House committee and was asked what products could Congress not compel people to buy, I held up the yellow pages of the D.C. phone book and said, under the theory I think the government will eventually put forth in this case, every product in this book that I can find, starting with aardvark rentals and going to Zydeco bans is not something Congress could require people to buy because it would be, requiring commerce. The health care area is where this is not some theory that someone is making up. People are participating in the financing of their health care. Insurance is the standard method of doing it. Would everybody who doesn't have health insurance raise their hand? Would any judge or lawyer be without it? It's hard for these people to find a plaintiff. So the idea that this is some deep incursion into liberty to make something do that literally virtually everybody almost wants to do, everybody who can afford it wants to do it. So in this instance, what you can say is where participation in health care is unavoidable, Congress is regulating how you pay for it by providing a modest financial incentive to have coverage in advance when that is critical to the functioning of an overall scheme and necessary and proper to make the insurance reforms workable, seems to be like an easy question. Could Congress say everybody has to buy a General Motors car? No. Should they even if you have other constructs, should you be required to buy a Chevy Volt so that we get the price down by having enough purchasers to make it worthwhile? That's another question, because people could say, I'm just never going to be in that, in that market. The fact that Randy's client and Kevin's, they had to give up one of their clients. It turns out she went bankrupt, and part of it was she left unpaid medical bills. So this is a real example of how this is simply not forcing someone to participate in a market they're going to be in. I think the argument has changed. Paul Clement made a concession in the 11th Circuit that I thought was extraordinary. He said that you could require people to pay double if they showed up at the hospital without insurance. And in response to a question, could Congress reverse the Emergency Medical Treatment Act and forbid the treatment of people without insurance as a way to get people to have coverage? He said, yes, they could. It seems to me incredible that you can have incentives for people to buy insurance that includes charging them more than they could possibly afford, or requiring that they be left bleeding on the sidewalk outside the hospital, but you can't create a financial incentive not to exceed 2.5% of income for people to have insurance as a means of providing this. Morrison and Lopez are on the other side of the river. If there's a box of commerce among the states, those were outside the box. Possessing a gun and happening to be near a school, or committing an act of violence against a person on a local street, there was this attenuated notion that they affected something inside the box of commerce. This is a regulation of commerce itself, and nothing in this calls into question. I think actually the question comes down to this, and I'm going to try to state this fairly, Randy, and I don't mean to state this pejoratively. Can the Chief Justice fashion a rationale for sustaining this law, a principal rationale for upholding the law that would not extend to a naked requirement that Americans purchase products that Congress wants them to purchase? I think the answer to that question is indisputably yes. And I think one of the weaknesses of the position is that you're telling the Chief Justice that no matter how compelling the case may seem to be, that it makes sense to incentivize people to have insurance and avoid all this uncompensated care passed on to other people, there's no way you can fashion a principle that you can apply. I think that once you're in the Supreme Court, they're going to say, this would lead to an unlimited, uncabined power only if we wrote an opinion that says we're upholding this on the theory that there are no limits and Congress can do whatever we want. But why would we write such an opinion? I don't think they will. I think they'll uphold it. I think the opinion will say, it will cite Judge Sutton's statement that people are involved in risk management presently. Self-insurance is an elaborate activity, as elaborate as having insurance. They will cite Judge Silverman and say, we need not go that far because we're not compelling commerce. People are going to engage in the consumption of health care. And I think that's the last we'll hear of it. But I make one more point, then I'll end. This is a long filibuster, but just there's a powerful point that Paul makes at the beginning. If Congress had really had this remarkable authority, it would not have waited 220 years to exercise it. Well, you know, no one doubts that Massachusetts had the affirmative legislative authority to do it, and they waited 210 years to exercise it and haven't exercised it since. So I think that's a logically flawed position. It is said that this is both extremely attractive as a power and 83% of the people are opposed to it. I think you should choose your argument on that score.
Thank you, Walter. I'll ask one question of Kevin Marshall and then questions from the floor. Kevin, as I think both you and Randy pointed out, Congress could have adopted a tax like the Medicare tax to subsidize health insurance for millions of Americans who can't afford it. If that would be okay, how can it be unconstitutional to pursue the same end by means of providing a financial incentive to buy insurance in the form of a penalty for not buying it when, as I think Neal said, if that's what you do, if you just pay the penalty, you're not violating the law. You're fine. It's not that heavy a penalty either. How can that be unconstitutional?
Let me just first start by thanking Professor Dellinger and Neal for the flattery of only attacking Paul Clement's arguments. There is another brief in the case by the NFIV, Randy and me, and I'm glad we've emerged unscathed so far from this panel. But to answer your question, the short answer is that if you pay the penalty, you're not complying with the law. What's remarkable about the individual mandate, and very different from a tax, is that you don't get the option. So let's say that in a particular month, you don't get health insurance. You pay the penalty. You're still, under the law, actually required to go get health insurance. So it's very different from your standard tax where the choice is either A or B. That's the short answer to why they couldn't do that. We're focused here on the problem of alleged cost shifting. And I want to pick up on something Professor Dellinger said, which refers to one of our clients. And I think it's actually quite instructive. So Mary Brown filed for bankruptcy. The government likes to point out that in her bankruptcy filing, she had $4,500 of unpaid medical bills. Well, she also had $55,000 of other unpaid bills. All of bankruptcy is about cost shifting. Why is cost shifting in the healthcare field so different from cost shifting in any other field that it would warrant regulating that and not other forms of cost shifting and uncompensated obtaining of goods or services? We submit it's not. Further evidence of our point that there is no limit if you accept the government's theory here. I do appreciate Professor Dellinger's concession that Morrison and Lopez actual precedents involve situations that are outside the box of interstate commerce. But what's interesting is that he, and to a greater extent Professor Katyal, have said that what we have here is an effort at a national solution to a national problem. That is precisely the argument that was made in Morrison with regard to violence against women. Similarly, we have an argument that what we're talking about is interstate commerce. Lopez involved guns. 95% of guns travel in interstate commerce. Again, how is that so different from what we have here?
Thanks for that answer. Now, any questions from the floor? Sir.
Hi, Trevor Burst from the Cato Institute. My question is for Professor Dellinger. It seems really odd because you're making a kind of a fit analysis for establishing jurisdiction over someone because you admit that the category of people who don't have health care or health insurance is not coextensive with the category of people who cost shift. So would you be willing to draw a line at which you would say they didn't establish jurisdiction, or does it seem hubristic to establish jurisdiction on a fit analysis as opposed to after you determine that Congress has jurisdiction, that's when you do a fit analysis of rational basis or whatever review for that? If only one person was cost shifting who didn't have insurance, would that be sufficient? No way of putting that.
That's a good question. And at some point, I think with any congressional regulation, the court will inevitably have to will inevitably have to draw a line. But most people who possess marijuana that they've grown at home will be able to take precautions so that it doesn't enter into the national stream at all. There's also one other aspect of this. This is an as-applied challenge. One of the conservative principles is that courts shouldn't, strike down. I'm sorry, this is a facial challenge. I misstated that backwards. This is a facial challenge, and facial challenges are especially disfavored by conservatives. And Judge Sutton, in his opinion, goes through all the categories of people who are clearly already engaged in activity. That if you could find someone, if Bill Gates can demonstrate that he's not in compliance with the law, but that he will never impose a problem, maybe he can win an as-applied challenge. I'd be happy to bring it on his behalf, or the Unabomber somewhere who's never going to use could bring this on this half. But I think that's inevitably a problem anyway. But this is not a tail wagging the dog. You can look at the figures of people who, and even for those people who do not have insurance, who will not impose cost transfers, it's a critical part of their ability to go without insurance that they know that the public is their backstop for catastrophic care. That is, they're already counting on the fact that if they have a catastrophic event, it's going to be taken care of. They could be, but as a class, the important backstop is that there will be catastrophic coverage, not just because Congress adopted EMTALA. Most of the states that are suing have their own laws that require emergency medical treatment to be provided to those who come without insurance or means to pay for it, and there's a 1,000-year tradition in the medical profession of doing it. All of which is radically different from a flat-screen television. If my team makes the Final Four, if I'm a loyal Norfolk State alum, and my team makes it to the Final Four, I don't get to rush into Best Buy and say that the Emergency Flat-Screen Television Act requires you to give me a flat-screen television and impose the cost on all the other customers, right? And if that were the case, it would be quite different. That would be the analogy, and that's why the incentive makes more sense in this context than in others.
Yes, next question.
Yeah, I'm Eduardo Siegel, I'm MDJD. I propose that the litigation is premature for these reasons. The obligation to purchase health insurance does not exist in the ACA. There's no such thing in the statute. Section 1501, aka 5000 AF1, talks about a requirement to maintain minimum essential coverage. The minimum essential coverage can be maintained via 5 different means described in subsections A through E. And subsection E allows the HHS secretary to practically cover everyone and thus eliminate the penalty. The exceptions and definitions of sections A through D cover more than 90% of the people with things such as Medicare, Medicaid, CHIP, employee, etc. Depending on the regulations that are yet to be written, almost everyone will be covered via the existing network, for example, free clinics, mandatory hospital
Could you
services.
bring it to a close and make it
So
a question?
the point is that because there is no mandate and there's only a requirement to maintain minimum health insurance, which can easily be accomplished via regulation, isn't it premature or perhaps irrelevant?
Randy Barnett?
Well, the government's not construing the statute that way, and no one has. If it didn't apply to anyone, it wouldn't address the problem of cost shifting, let's say. So the only way that this statute can address the problems it purports to address is if it actually does make people buy insurance. So I think the case will be heard on that basis, and it'll be resolved on that basis.
Next.
Go ahead.
Oh, sure, go ahead.
I
I'm
think I
sorry.
heard reference to subsection E. I won't spit out all the numbers. That actually is the exemption from the penalty, not the exemption from the mandate. And one of the extraordinary things about this law is Congress exempted one group of people from the mandate and a different group of people from the penalty, which means it expected there would be people not subject to the penalty who still complied with the mandate. That distinction is critical for the Anti-Injunction Act, sorry for the brief reference, but also for the tax power question, where we say we're challenging the mandate. It's a freestanding legal requirement, has nothing to do with taxation, and can even be analyzed apart from the penalty.
Some people have said the administration would do whatever it could to avoid a decision in this case before the election. In fact, that was obviously never the case. I think there's a least credible argument to be made that the case isn't ripe, there's no standing, is barred by the Anti-Injunction Act, when there's a real no standing in the sense that people have to speculate that they have to save money now to be able to pay the $95 in 2015, but they won't be eligible for the hardship regulations that haven't been drafted. The rule is if anybody actually has to pay the tax penalty, they can sue for a refund, on April 15th, 2016, I think it is. But the government has decided to not fight on all of those jurisdictional grounds.
Thank you. Next question.
Mike Gentine from GW. This question would best be directed toward Professor Katyal since he made the statement, but Steve's no longer with us. I would hope I could get some response from one of you. He suggested that we shouldn't be talking about broccoli or GM cars because those are absurdities that the political process would never allow to come into reality. Would there have been a point in constitutional history, in Commerce Clause history, when someone would have said the precise same thing about the requirement to buy health insurance? And if so, does that suggest that that argument, that pushback, is simply invalid because it didn't prevent this one?
Well, one comparable observation I thought of when I heard Walter talk about Champion versus Ames, which is the case in the 20th century that upheld the power of Congress to prohibit commerce among the several states rather than merely regulate it, is at the time, that case, if you actually look at the reasoning of that case, it's actually very limited as to why, under what circumstances it's reasonable to allow Congress this power. And it had to do with, for example, reinforcing the fact that some states had prohibited lotteries, other states had not. It was difficult for those states who had, in order to protect their boundaries, if these lottery tickets could get shipped in from out of state. So it was a way of bolstering states' rights, it was argued. But that's not the way the case is cited now. The way the case is cited now is Congress has the power to prohibit goods that travel between interstate commerce, prohibit anything that travels between interstate commerce. All those limits, all those things that justified the outcome in that case, they're gone. They're not even remembered, and they're not legally relevant. All that's relevant is Congress has the power, and that's exactly what's going to happen here. Stuart, if you don't mind, I'd like to just, because I think we're almost out of time, and I just wanted to respond a little bit to Neal's, and I'm sorry he's not here. The 4 limiting principles that he proposed and see whether they really are limiting principles or not. I just want to just go down them really, really quickly, because you're going to see that they really are not limiting principles in the sense of judicially administrable limits on the commerce power. The first one was the Bill of Rights. The Bill of Rights has nothing to do with the scope of the commerce power. It cuts across all powers, and in fact it cuts across the police power of states equally to the commerce power. So the converse is that states can do anything that's not prohibited by the Bill of Rights, and so Congress would have the same scope of power as the states did if that argument held. It's a truly interstate problem, and states are not competent to handle this. That is not a principle of constitutional law. It was something argued at the Constitutional Convention as a principle that ought to be put into the Constitution, but was not put into the Constitution. And the Court has never adopted that as a judicially administrable line that it was prepared to draw. The fourth one, I skipped number 2. The fourth one is politics are ultimately the test. That is a denial that there's a judicially administrable limit. It's basically, that's what you do whenever there's not a judicially administrable limit. You say, well, let the voters vote the guys out. That's your limit. Well, that's not an answer to this problem. The only one on his list which really resembled a legal limit was this is truly economic. And that harkens back to a limit that was placed on the Necessary and Proper Clause by the Court in Lopez and Morrison that limited the scope of the Necessary and Proper Clause to economic activities, to the regulation of economic interstate activities. So that does harken back to a legal limit. However, if the reasoning of this case is accepted, then virtually that eliminates the line between economic and non-economic, because any activity, and in particularly any failure to act, could then be deemed economic because of the effects. The economic effect of failing to act, not selling your house, is an economic activity because it obviously affects the real estate market. So that's the only potential legal limit on his list of 4, and that one, the way it's being construed and applied in this case, provides no limit at all.
We'll take your question, but I have a quick follow-up to what you said, and I'll ask Kevin just for equal time. When I was in law school in the 70s, we were taught that, of course, the commerce power is illimitable. It's been illimitable since 1937. There won't be any limit on it ever. Political safeguards of federalism are all you've got. That was pretty much the law for 50, 60 years, and the world did not come to an end. So should we really be that worried if it becomes the law again?
Oh, Kevin?
Did you want to go ahead?
No, go ahead. You go first. Then I'll cite your great-great-grandfather. Go ahead.
I wish. Yes. I would say that at a point when federal power is so, as great as it is, setting some limit on it is more important than ever. Even though the courts were upholding everything over those 50 years, the idea of limits was not abandoned, and Congress still had to think about what it was doing. So, for example, when the Civil Rights Act came up in the 1960s, there was a serious question whether the commerce power or in the 14th Amendment would authorize those laws, and Congress took it very seriously. The farther you go from identifying any limits to congressional power, then less and less that happens. And we saw that, I think, in the debate over Obamacare. It doesn't matter so much to Congress. So the enumerated powers is a wasting asset, and the longer you go without replenishing it, the greater the dangers.
If I could respond, and to the very good question from GW, would anybody have, would it have been a parade of horribles to say, could Congress in the next century pass a requirement or incentive to have health insurance coverage? You know, Kevin Marshall's great-great-great-great-grandfather, John Marshall, said that the power extends to that commerce which concerns more states than one. And the category of what is included in that commerce which concerns more states than one has expanded exponentially because of increases in transportation, communication, et cetera. They would have thought that there was a substantial body of commerce that didn't concern more states than one, but developments outside law have made that different. Remember, we are a country with completely open internal borders, so that someone who doesn't get preventive care in Massachusetts winds up in Florida. We have the cost goes, we have national auto worker contracts that apply in auto factories in California and raise insurance costs in Pennsylvania. So that there is that category of commerce that concerns more states than one that has expanded. In terms of this being an incursion in liberty, I know, this being the Federalist Society, that we know that economic liberties are important, but that is still a valid line, and one where you have to write a check either to the government or write a check to your insurance company. It's not as if this is actually regulating how doctors conduct medical practice or what they have to tell their patients or what kind of procedures doctors have to engage in that they and their patients don't want. That's a wholly different, set of issues.
Thank you, Walter. We're out of time, but we do have one last question, and I owe it to him to let him ask his question since I usurped his time. Yes, sir.
Thank you. Professor Barnett, you mentioned that you thought the individual mandate was unprecedented and uncabineted. And I was curious, I can think of one individual mandate that is authorized by another part of the Constitution that could never be used under the Commerce Clause, but could provide the basis for reasoning backwards to figure it out. And that is the military draft, which the government pulls you out of society and subjects you to a service contract and et cetera. And I think everybody would agree that that could never be done under the Commerce Clause. Perhaps that's a starting point, and you could reason back from there.
Well, thank you for that. In the longer version of my talk, I do discuss the duties that the federal government can impose upon us and has imposed upon us, and the draft is one of them. But when the draft was challenged after World War I as being unconstitutional, in fact being involuntary servitude under the 13th Amendment, the Supreme Court rejected that argument because they said that no one could complain about this because it was part of the supreme and noble duty of citizenship, that one has to serve one's country and protect it if called upon to do so in return for the benefits the country gives you. So that gives you a clue as to what distinguishes that duty, the duty to serve on juries, the duty to fill out a tax return, the duty to serve on a posse comitatus. If a U.S. Marshal is there to enforce federal law and you're in the vicinity, you can actually be rounded up into a posse. All of these duties are duties that you owe to the government itself, that are necessary for the government's preservation and are part of the fundamental duties of citizenship. If this duty is allowed, essentially what the court will be acknowledging is that there is a national duty of citizens to do whatever Congress deems convenient in its regulation of the national economy. And that, if the duty of citizenship extends that broadly, then the relationship of citizen to state has been fundamentally reversed. No longer ought we be called citizens of the United States. We ought to then be called subjects of the United States, and the Congress will be the master, and we will simply be their servants.
I would say the distinction he's drawing is precisely the distinction between an individual mandate that I go buy something from Aetna and send money to them, and a tax. What is a tax? It's a mandate to send money to the government. Who it goes to is a critical distinction.
Our time is more than up now. Thanks to all our panelists for a terrific discussion. And thanks to the Federalist Society for sponsoring this and other terrific debates.